Thank you. I suppose, firstly, to the panel, Claire, congratulations on last night's efforts. We were there as well, but well done on your recognition. A little bit about Coleman Greig for the panel. Some of you may know the firm, some of you may not. Based in Parramatta, largest commercial law firm outside of the CBD. Certainly, our firm has been on a journey over the last 20, 25 years. Traditionally, we were a very traditional suburban law practice. These days we have about 90 staff and service a wide variety of clients, subsidiaries and multinationals, state government clients, franchisors and high net worth individuals. I've been with the firm for the last 10 years, and certainly part of my attraction with the firm is their propensity for innovation. And we talk about, sometimes innovation unfortunately has the connotation that you've got to come with the Big Bang Theory all the time, and certainly internally we talk about incremental innovation. As many of the presenters have spoken here today, it's a very competitive environment out there, but interestingly, certainly the profession as a whole, I think there's lots of room for improvement and change management, but again, as we know, the profession I suppose moves at a glacial pace in terms of change. I suppose part of our challenge being based in Parramatta is attracting talent, and certainly what we're finding with the new generation coming through is that certainly that talent is attracted to doing things in a 2016 way. As simple as the way in which they engage. I walk outside of my office and go, I want to do this, is there an app for it? And I get bombarded in terms of, yeah, try that app, Warwick, try that app, Warwick, try that app, Warwick. And I think for us, part of our positioning and selling point, because again, being based in Western Sydney, we do have to work that a little bit harder to attract talent, is our ability for our young ones to engage and utilise that technology. And that has been driven from the top down in terms of embracing technology in all that we do. Certainly, what we do around our marketing and business development piece is quite, I wouldn't say it's necessarily innovative, but for the firm of our size, certainly our position in the marketplace out there in Western Sydney is all around, I suppose, partnering with our clients, educating our clients, and part of the reason that we were able to do that, and this is very simplistic, but we have some pretty strict data business rules around the way in which we manage our data. We're just in the process of acquiring a small firm at the moment, and we've just imported that data. Now, as a small firm, the way in which they manage their data is quite poor because they don't see that as important. But for firms who manage their client information, understand how they can utilise that data, sometimes the very basic things are the things that are missed, and then basically that has its own connotations in terms of other opportunities down the track. Certainly more and more these days we compete with the big end of town, and I suppose part of that ability to compete, and again we've spoken about some of the larger corporates today. I talk about Coleman Greig, we don't act for CBA or BHP or Qantas, but we act for everybody that supplies into those companies. But certainly the ability to provide real-time reporting and manage volume is a key to be able to service some of those larger clients that we look after. I'll give you an example. We settled 120 units on Friday. We were provided the occupational certificate Thursday week prior. We, through a combination of technology, workflow and an outsourced provider that we use, those letters were sent to the purchasers within 18 hours of us receiving that occupational certificate for 120 units. And on Friday, unfortunately, we still had to write cheques in 2016. We had to produce 400 cheques to manage those settlements on Friday. So there is, I suppose, an example of where we've used technology, but we still have a foot in both camps, old school and new school. And the fact that we had to manage 400 cheques and the signatures that go with that cheque is quite ludicrous, I think, in 2016. Mobility, and again, the ability, and a couple of presenters have spoken about this previously, the ability to run your practice from this little phone or this little device, I think is not only a game changer, it's just these days a ticket to ride. If your firm can't provide that or can't do that, I think there are going to be some firms who don't embrace technology and don't use it as an opportunity to move forward, and some of those firms I think will face some challenges down the track. The other thing I know, which was spoken about at the conference in Melbourne earlier this week, is that for many firms, they have great practice management systems, they have great technology, they just don't use it. For many firms, the ability to actually invest further with the investment that they've already made to make significant improvements and enhancements is always there. And again, the ability for firms, I think, to actively engage with their practice management providers and not see them as the enemy, but see them as the opportunity to improve the way in which they do run their business and ultimately improve the way in which they service their clients. I spoke about incremental innovation and the whole challenge in terms of the profession, in terms of change. I think firms who embrace that whole concept of innovation, it does generate its own momentum internally, and certainly, some of our more traditional practitioners, and I'll give you a brief example. About 18 months ago, 2 years ago, we tried to implement a paperless office. And I can say within the first 3 months that was an abysmal failure. Part of the reason it was an abysmal failure is because we spoke about paperless.
Yes.
And
didn't like the term.
No, not at all. So I went to one of my most traditional principals, and I said to him, I said, in terms of emails, what percentage of email do you get through from your clients in terms of correspondence? And he said, 85% of my clients would communicate with me on email. And I said, and how do you communicate back? And he goes, 85% of my correspondence goes out on email, Warwick. And then we started having the dialogue around looking at the way in which, fundamentally, as I mentioned earlier, the profession still has a foot in both camps. We still run hard copy files, but most of our clients deal with this electronically. When we actually sat down and looked at the processes involved, the amount of duplication that goes on, terrific. I have one principal who used to, every time he used to take annual leave, is print his entire inbox to give to his secretary to file over the break. That doesn't happen anymore. That particular team has gone completely paperless. But I think part of the challenge in terms of managing that change is the way in which it's sold and the way in which it's delivered. And again, as we've successfully done in our practice, looked at where the duplication was occurring and providing the opportunity, particularly for our support staff, to service our clients better and service their internal clients better, we're probably about 85% there. Interestingly, we have a family law practice, and unfortunately at the federal level, family law is still very much paper-driven. So sometimes we are challenged, not by what we want to do as a business and as a firm, but unfortunately the judicial system and the way in which they operate and the way in which, I suppose, investment or lack of investment has occurred within the judiciary, both at a New South Wales level and also at a federal level. Carolyn, would you like to, I suppose, talk about from a litigation experience and some of the challenges in terms of technology and working as a practice and having a practice outside of the CBD?
All right. Well, I've been practising for over 20 years. I'm actually a member of the Litigation and Law Practice Committee, so thank you very much for having me. I think operating in the suburbs has its own challenges in litigation, and we actually need to rely upon technology so much more and use it so much better than our colleagues here in the city. And the reason I say that is if we have a 4 o'clock deadline and a judge wants the court book or various documents delivered to his or her chambers by 4 o'clock that day, that means that we need to have made sure that we have got them out of our door at Parramatta by 2 o'clock. That means that we need to be working that much harder, that much better, that much more efficient. And I guess where we find it very, very challenging, and if we're finding it challenging in Parramatta, I'm sure that the practitioners in the regional centres would even find it much, much more challenging, is that the use of technology within the court system, while it's come a long, long way, still has a much greater way to go to assist the practitioners in those areas. To give you an example, we had a statement of claim just in the local court which needed to be filed. You can file online in most state court for most things, because the defendant was an international company, we could not file that statement of claim online. This is a local court matter. There's not a lot of money in it, and yet we simply couldn't do it online. So we had to arrange for somebody to come and file it. And it's just an additional expense, which is completely unnecessary. There's been some talk of outsourcing, and in fact we do outsource some of our work overseas. And that doesn't need to be the big stuff. That can be the small things. That can be the billings. That can be correspondence. We have some fantastic typists overseas that type up some fantastic documents for us. And so we actually do use that outsourcing to in a much smaller capacity. What else, Warwick, were we going to say?
I think the other thing
yes.
in terms of certainly some of the processes, I'm on an advisory committee as part of the Australian Legal Sector Alliance, and AusLSA is really looking around the whole sustainability piece. That advisory board is being funded by the New South Wales Department for Cultural and Heritage, with a view that they're trying to understand what are some of the blockages around using technology more within the profession. And I did a session with our litigation team the other day, and something as simple as the handing down of a judgment, we need to travel in to the city from Parramatta, because most of our, particularly our Supreme Court matters, are lodged in town, for a 5-minute appearance, and then schlep back out to Parramatta again. Now that's a cost for our client. And certainly the way in which, and that's something that's really simple as an example, ultimately the bulk of that judgment is then handed over and you've got to go away and read it. Why fundamentally can't that be done online? So again, having a look at some of those processes, and that's what I mean, part of the profession is stuck in the old school way, and part of that reason is because the way in which the system operates. Then you've got firms like us who are really keen to participate in the new world in terms of technology. The other example I'll give is PEXA. Certainly the take-up of PEXA has been relatively slow. Part of the reason for that is you need all parties to participate, and in some instances there could be 8, 10, a dozen parties for one transaction. Now, if one of those parties choose not to play, everything's got to be done manually. And again, I think, interestingly, I've had a 20, 25-year career in professional practice management. I was involved in the accounting profession in 1999 when the ATO turned around and said to all practitioners, you have to lodge electronically. That was a decree. It was 3 years in the making, but you had to lodge electronically. Now, unfortunately, at that point in time, we did have practitioners who left the profession. Most of those people were nearing retirement, but there were people who just checked out because they didn't want to have to get their head around what it was going to be like to deal with the ATO electronically. Now, you imagine dealing with the ATO in 2016 in a paper world. It just, in terms of delivery, cost, turnaround time, all that type of stuff, I don't think it'd be effective. So certainly accountants tend to be, as I've always said, a little bit more progressive than lawyers, but certainly I think the profession still, in terms of the legal profession, it's got a long way to go to where we can get to in terms of delivery of service and delivering it in a cost-efficient way.
And if I can also add to my earlier comments, we do a lot of work for subsidiaries of multinationals. And as a result of that, we've got legal counsel overseas. And I know that Connie earlier talked about the US being ahead of us, and I have to say that because I'm having telephone conversations through various apps called Go Meeting or Skype or whatever it is. And those are the expectations. The expectation is also that we are available 24/7. And I think whilst we may, wish that sometimes life would be a little bit slower in pace, it's not ever going to be like that again, I don't think so, because the expectation of our clients is that they want us to do it better, and they want us to be available and to provide that fantastic service. And that means that we need to be available for them.
Are you finding that you're being asked more and more frequently to provide advice on discrete aspects of a matter, and then the client perhaps does the rest of it in-house or that sort of thing?
It can be the case. It can be the case, but I guess we've always had a very holistic approach to the way that we service our clients, and part of it, I know that a couple of other people have talked about understanding your client and understanding their needs, and so part of it is us really having that conversation with our client, and whilst they may only want that particular sector or that particular piece of advice, you can get to understand their business and work with them a lot more effectively if you actually have a better understanding of them from a holistic approach.
I hear what you say about the people coming from the suburbs or the regions, being a regional practitioner myself. You do have much more difficult access to delivery of things.
Yes.
Are you finding the technology for online filing working for you, or do you have suggestions as to how particularly the state system's working?
I think that's right. I think the federal system is ahead of the state system. When I said the state system has come in leaps and bounds, it certainly has over the last couple of years. I think in 2014, when I was sitting on the Civil Registry Users Committee, we were talking about the online filing system, and it was very, very limited. I think probably the biggest issue that we have is in relation to subpoenas, about getting access to documents produced under subpoena. We have to instruct an agent to come in to photocopy those documents and deliver it back to us. I don't understand why the court can't just have all those documents scanned when they're received and put into the system so that we can access it when we've got the orders. Bulk documents, the state system really can't deal with a bulky affidavit. Now, you've got Supreme Court matters and we deal in affidavits. It's just an unfortunate part of our life as the litigators. We deal with affidavits and bulky affidavits and exhibits. Again, that's really the system has a shortcoming there significantly. Yes. Look, I'd have to say also, I think it's a very case-by-case basis. Certainly some judges are quite up to date, I guess, with emailing and understanding all of that and accepting various documents online, emailed to them. The others don't. But again, I think perhaps part of that challenge too is as solicitors is that sometimes the correspondence that goes to the court is not necessarily the right type of correspondence that should be sent. And I guess that's part of the challenge that we as solicitors have going into the future.
Great, thank you very much. Any questions from the panel?
I've got a question, if I can start. I don't know which of you would like to answer this. You may both want to answer it. I'm just interested in how the provision of law is going to change in this sense. And we've seen change. Perhaps you might want to summarise how you've seen this, but people working in the office, do they always work in the office? Do they work elsewhere? Do they work full time? What sort of hours are they working? How easy is it to recruit people with the appropriate skills? What sort of effort do you put into mentoring and training them to acquire those skills? How is that changing, and what's your perception about that in the future?
I think certainly for a firm like ours, we embraced the whole part-time arrangement 10, 15 years ago. Carolyn originally came from a part-time basis. And
I think I was the first part-timer.
Exactly. But now 74% of our staff are female. I cannot tell you, we've got about 90 staff, but of those there'd be about FTE equivalents is about 65, so that gives you an indication in terms of part-time vis-a-vis FTEs. Part of the reason I think that where we've got to in the market has been reflective of our ability to work with our staff. We hire locally, and generally we find if we hire locally, that talent will stick. Certainly for female staff, the flexibility around going and having children, working from home. Again, our culture is not about being in the office. Our culture from a service delivery point of view is actually, I don't want to see you in the office, get out and speak to your clients. And if that means that you can work from home for the first 2 hours and go visit a client in, Wetherill Park, or go and visit a client in St Mary's, so be it. But as long as you can access everything from here and basically run your practice from your mobile phone, that ability then to attract and retain talent and work with them in terms of as they go through their stages in life. We've got a lot of staff, particularly female lawyers, who've been with us for 15, 20 years, and we've seen their children grow up. And many of those staff will ultimately become the next generation of principals for the firm.
What about recruiting? Is that harder? Is it easier? In the sense of the catchment area shrinking or growing?
So interesting for us, I was having this conversation earlier this morning, attracting support staff and attracting junior and intermediate lawyers, no problem at all. Certainly what we are seeing now, and it's only literally been in the last 18 months, combination of a couple of things. Certainly the firm has received, I suppose, national recognition. We've won a couple of awards, and that certainly puts you on the map, number one. Number two, the cost of housing here in Sydney has obviously, as we all know, continued to escalate. So traditionally, those people in their late 20s, early 30s, who might be a senior associate or a junior partner, traditionally would have, and I'm generalising here, guys, would have lived on the North Shore or the eastern suburbs. A lot of those people are actually moving west. They've got to afford to live in the inner west, and even the inner west now is expensive. Places like Epping, Borkham Hills, the vast majority of our staff come from the hills area and further west. And certainly what we are seeing now and able to actually engage and recruit is those people who are sick of the commute and looking for, I suppose, a great experience. The joys of our practice, whilst we're certainly not as big as the big boys, we're a nice size to get things done, and we're nimble enough to, turn things around quickly. So certainly we've been able to engage and recruit some senior talent, which traditionally, prior to 2 years ago, we would have struggled to ever do.
Elizabeth.
Thank you, Pauline. I guess 2 very brief points, if I could. Very interested to hear you articulate earlier that one of the challenges is the actual use of technology. We've got technology, we've got access to data, we have information. My own personal experience is we've got a wealth of data. I heard the fellow from Osley earlier say that he's surprised that there are still so many practitioners who don't understand some of the basic search engine tools available in Osley alone. And we're hearing across the board, training and more training is actually one of the key features of, I guess, retaining relevance and that nimbleness that you referred to earlier. If I could comment on litigation and the courts and having that foot in 2 camps, I understand that the Attorney General's giving a presentation next Thursday on how technology in the courts, and you can't comment that on now because that's in the future, but it's ironic that that is actually a presentation that the Attorney General's giving, and how the courts will affect legal practice. Do you have any comments on how, I guess, immediate improvements the court could make?
Oh, golly.
Maybe the top 3.
Maybe the top 3. I think the ability to communicate with the courts. I think the hotline is they've got a hotline now which you can ring if you've got an issue with a document, filing a document, whatever it is. But that is not actually serviced by court staff. It's actually serviced by an external entity, which then will approach the registry after that. I guess just the second thing would be about the document management. I think that is probably our biggest issue, I'd say, with the court system the way it is. And thirdly, the delays. One of my solicitors had an injunction which should have been heard 2 weeks ago in the federal court. It hasn't been heard yet because simply there was no judge to hear it. It's just appalling. So, and look, we've heard lots in the media about the delays in the federal court, particularly in the family court as well. And I think it is under-resourced.